8 years ago, my brother Derek called a family meeting. He used that phrase specifically, family meeting, which I have since come to understand is the phrase used when a decision has already been made and the meeting exists to present it rather than discuss it. Derek was good at that kind of language. He had spent 20 years in corporate management in Denver and had brought the vocabulary home with him. We met at the Greystone house, my parents' house in East Nashville, on a Sunday afternoon in September. Derek flew in. Pamela drove up from Atlanta. I drove 12 minutes from my apartment. My mother Helen had been diagnosed with early-stage dementia 4 months earlier. My father Gerald had been managing Parkinson's for 2 years. The house needed modifications. The appointments were multiplying. The situation, Derek said, required a plan. We all agree that Mom and Dad need more consistent support, he said. He had a legal pad on the table. The question is how we structure that. I can increase my visits, Pamela said. Maybe once a month. That's a start. He looked at me. Nora, you're the closest. You work from home. Your situation is the most flexible. I was 33. I had a marketing coordinator position I had worked up to over 7 years. I had a 1-bedroom apartment 12 minutes away. I was single in the way that my family had always interpreted as available. What exactly are you proposing? We're thinking primary caretaking. Day-to-day management. Appointments, medications, the house. Derek and I would cover financial contributions from our end. Pamela said this with the specific confidence of someone offering something they believe is generous. What does financial contributions mean? Derek named a monthly amount. It was less than my rent. And my job? You can work from here. Mom and Dad have the study. It's a much bigger space than your apartment. A pause. Nora, this is temporary. When things stabilize, we reassess. And of course, when it comes to the estate, Derek and I have already agreed that your contribution will absolutely be reflected. Your contribution will absolutely be reflected. I wrote that phrase down when I got home. Not because I believed it would be honored, but because I understood, even then, that phrases like that need to be documented. I gave up my apartment in November. I moved into the Greystone house with my parents. I set up my work equipment in the study. The temporary situation lasted 8 years. Derek visited 4 times. Pamela visited twice. They called regularly. Every call ended with some version of, "We don't know how you do it. You're incredible." I did it because someone had to. I was incredible because there was no one else. I am going to tell you what 8 years of primary caregiving looks like, because people who have not done it tend to imagine something softer than it is. It looked like a medication schedule on a whiteboard in the kitchen, updated every time a dosage changed or a new prescription was added. At the peak, my father was on 11 medications at 4 different times of day. Cross-referencing them for interactions was a skill I taught myself using 3 different reference books and a spreadsheet. It looked like nights. My mother, in her dementia, stopped sleeping normally in year 2. She was awake at 2 a.m., at 3 a.m., confused about where she was, sometimes frightened, sometimes calm. I installed a monitor in her room so I could hear her. I slept lightly for 6 years. It looked like appointments. Neurologist, cardiologist, physical therapist, occupational therapist, geriatric psychiatrist for my mother's behavioral episodes. I kept a shared Google Calendar that Derek and Pamela had access to. In 8 years, Derek attended 2 appointments. Pamela attended 1. It looked like the specific grief of watching someone you love not recognize you. My mother stopped knowing my name in year 4. She still knew that I was someone safe. She would reach for my hand when she was confused, but she did not know I was her daughter. I made peace with that slowly and imperfectly. My father knew me longer. He would have periods of clarity, sometimes stretching for days, where he was completely himself, precise, warm, paying attention. During one of those periods, in year 6, he said something I wrote down. We were sitting on the back porch after dinner. It was late spring, warm enough to be outside. He had been watching the yard for a while. Nora. Dad. I want you to know that I see what you're doing. I want you to know I understand what it costs. I did not say anything. Your brother and your sister, they have their lives. I'm not angry at them. But I see the difference. I see who is here. I'm okay, Dad. I know you are. You're the most capable person I've ever raised. A pause. I'm going to make sure you're okay after I'm gone too. I need you to know that. I told him I wasn't worried about that. He said, I am. He went inside before I did. I sat on the porch for a while. The yard had the specific stillness of a late spring evening in East Nashville. I thought about what he had said. I thought about the whiteboard in the kitchen and the medication schedule and the monitor in my mother's room. Then I went inside and checked the monitor. My mother Helen died in year 3. A stroke, in the night, quickly. I found her in the morning. I called Derek and Pamela. I called the hospice nurse. I handled the documentation. I organized the memorial service. Derek and Pamela flew in, were present for 4 days, and flew home. They said I had handled everything perfectly. I had. My father Gerald lived 5 more years. His Parkinson's advanced in stages, the tremors first, then the balance, then the cognition. He had good periods and difficult periods. He died on a Tuesday in October, at home, in the Greystone house, in the room where he had lived for 37 years. I was with him. The will was read 2 weeks later in Harold Voss's office on Church Street. Harold Voss had been my parents' attorney for 20 years. He was professional and efficient and had the manner of a man who reads wills with sufficient frequency that the emotional weight of the occasion has become procedural for him. Derek and Pamela were present. I was present. Harold's paralegal was taking notes. Harold read the document. The Greystone house, $480,000 at current appraisal. Split equally between Derek Walsh and Pamela Lawson. The investment accounts, $320,000 combined. Split equally between Derek Walsh and Pamela Lawson. The savings account, $85,000. Split equally between Derek Walsh and Pamela Lawson. Personal property, to be divided between Derek Walsh and Pamela Lawson at their mutual discretion. Harold looked up. That concludes the distribution. I looked at him. Is my name anywhere in that document? Harold looked at the pages. A pause. No. Not in any capacity. No, Ms. Walsh. I looked at Derek. He was looking at the table. Pamela was looking at her hands. When was this will prepared? 4 years ago, Harold said. 4 years ago, my father had already had 2 years of significant Parkinson's progression. 4 years ago, Sonia, Derek's wife, had begun accompanying Gerald to his appointments when Derek was traveling. 4 years ago, Gerald had stopped driving himself to most places. I thanked Harold. I stood up. I left the office. 3 days later, a certified letter arrived from a firm called Bryce Estate Law. The letter was from Catherine Bryce, of Bryce Estate Law, on 8th Avenue North. It was 3 paragraphs. The first paragraph identified Catherine as the drafting attorney and executor of a testamentary document created by Gerald Thomas Walsh approximately 2 years before his death. She said she had been holding the document in secure storage per Gerald's instructions, to be opened and delivered to the named beneficiary following Gerald's death and the reading of any prior estate instruments. The second paragraph said Gerald had been specific. He did not want the document delivered until after any prior will had been read, so that the named beneficiary would understand the full context of what the second document was correcting. He had planned the sequence. He had thought about the order of events. He had wanted me to sit in Harold Voss's office first, so I would understand what the second document was doing when it arrived. The third paragraph asked me to contact Catherine Bryce's office to schedule a meeting at my earliest convenience. It said the document she was holding named me as primary beneficiary of the Gerald Thomas Walsh estate and contained specific language she believed I would want to hear directly. I sat at the kitchen table in the Greystone house, the house that had just been distributed to my brother and sister, and read the letter 3 times. Then I called Catherine Bryce. "Ms. Walsh. Thank you for calling. Tell me about the document. I'll tell you everything when we meet. But I want to say this now, over the phone, because I think you need to hear it before you come in. Your father came to my office 2 years ago. He came alone. He was completely clear. He brought a handwritten list and he knew exactly what he wanted to accomplish. He sat across from me and he said, 'The other will doesn't protect Nora. I need one that does.' Those were his words. I wrote them down. I was quiet for a moment. He knew about Harold Voss's will. He was aware a prior document existed. He did not describe the specific terms, but he said the prior document had been prepared during a period when he felt, his word, pressured. He wanted to correct it while he still could. He came alone. Completely alone. No family member, no caregiver. He drove himself. That was the last time he drove himself anywhere, I understand. He made it his last drive. Catherine Bryce's office was on 8th Avenue North, in a building that had been a bank in a previous decade and still had the specific solidity of a place built to hold things securely. She was a woman in her early 50s with reading glasses on her desk and the particular manner of an estate attorney who takes her clients' instructions as seriously after their death as during their lifetime. She opened a folder on the desk between us. Gerald came to see me on a Tuesday morning, 2 years ago. He had found my name through a referral from his physician, not from any contact connected to your siblings or to Harold Voss. He was deliberate about the separation. He told me during our first meeting that he had chosen someone his family didn't know. His physician referred him. Yes. His neurologist, Dr. Anand Mehta. Gerald had apparently asked Dr. Mehta, during a clarity window, if he knew an estate attorney who could be trusted to hold a document confidentially. Dr. Mehta gave him my name. I thought about my father sitting in a neurologist's office, asking for the name of an attorney who could be trusted, during a period of clarity, while planning something he couldn't tell anyone. He brought a handwritten list, Catherine continued. She placed a photocopy on the desk. My father's handwriting. The careful, slightly tremored print of a man managing Parkinson's, the letters a little uneven but completely legible, the intent absolutely clear. A list of assets. Beside each asset, a name. Beside my name, a percentage. Beside each percentage, a note in parentheses. The note beside my name on the house line said, 8 years. He had written it like that. Not a percentage justification. Not a legal argument. Just a fact in parentheses. 8 years. He told me, Catherine said, that he had been watching his daughter care for him and his wife for years, and that he wanted to make sure the estate reflected that. He used the word reflected. He said someone had promised her that years ago and he didn't trust the promise would be kept. Your contribution will absolutely be reflected. Derek had said it 8 years ago at the kitchen table. My father had heard it, or heard about it, and had decided not to leave it to Derek's discretion. He came back once more, Catherine said. 6 weeks later, to review the draft and sign. His physician had documented his capacity at both visits. He was clear, consistent, and independent in his instructions across both meetings. She placed the signed document on the desk. The date was 2 years ago. The signature was my father's, tremored but deliberate. Witnessed by Catherine's paralegal and a notary. Gerald Thomas Walsh. 2 years before he died. The last time he drove himself anywhere. I am going to read you the distribution section of the second will, because my father chose his words carefully and they deserve to be heard. to my daughter Nora Marie Walsh, who has served as primary caretaker for both her mother and myself across a period of not less than 8 years, providing daily management of medical, pharmaceutical, logistical, and personal care without compensation beyond the cost of residence in the family home, I leave the following. The Greystone house, 70% of appraised value, with right of first occupancy and right of first refusal on any sale. The primary investment account, 60%. All personal property from the family home, with right of first selection before any distribution to other parties. The remaining 30% of the house and 40% of the investment accounts, divided equally between Derek Walsh and Pamela Lawson. The document then contained a paragraph I had not expected. I make this distribution not as a criticism of my other children, who have their own lives and their own obligations, but as a recognition that one child reorganized her life entirely around the needs of her parents for 8 years. That reorganization had a cost, professional, personal, financial, that is not recoverable. The distribution above is not payment for that cost. It is acknowledgement of it. I am aware of the difference. He had written that paragraph himself, Catherine told me. It was not standard legal language. He had brought it written out on a separate piece of paper and asked her to include it verbatim. I read it twice at the conference table. My father had known, during a Tuesday morning 2 years before his death, that acknowledgement and payment are different things. He had known that what he could give me was not the 8 years back but a document that said he had seen the 8 years. He had been precise about the distinction. I folded the copy Catherine gave me and put it in my bag. What happens next? I asked. I formally filed the second will with the probate court. As a document dated later than the Harold Voss will, it supersedes the prior instrument. Your siblings will be notified. They will have the opportunity to contest. Will they contest? Catherine considered. I would expect so, she said. People generally contest when the numbers change significantly. The numbers had changed significantly. Derek called me 2 days after Catherine filed the second will. His voice had the specific quality of a man who has spoken to an attorney before making the call and has been advised to remain calm. Nora. I think we need to talk about this second document. Catherine Bryce is my attorney. Any legal communication should go through her. I'm not calling as a legal matter. I'm calling as your brother. Derek. Dad went to an attorney alone, with a handwritten list, during a documented window of clarity, and created a new will because he felt the prior one had been prepared under pressure. That is the situation. There is nothing to discuss between us that changes it. A pause. The prior will was prepared properly. Dad was present. He understood what he was signing. For years ago, Sonia was accompanying Dad to most of his appointments. Including, I assume, appointments with Harold Voss. Silence. I'm not making an accusation, I said. I am describing a sequence of events that a court will also describe. He ended the call shortly after. Pamela did not call. Her attorney contacted Catherine within the week. The formal challenge was filed 11 days after Catherine submitted the second will. The grounds, lack of testamentary capacity at the time of signing. The argument, Gerald's Parkinson's had progressed to a degree that rendered his decision-making unreliable 2 years before his death. Catherine called me after reviewing the challenge. Their arguing capacity. He drove himself to Catherine's office. It was the last time he drove himself anywhere. I know. And Dr. Mehta documented the visit. A pause. Nora, I need to tell you something about the challenge that will be useful to hear now. The capacity argument is their strongest available argument. It is also not a strong argument, given what we have. Your father's physician documented 2 separate clarity windows that coincide exactly with the 2 visits to my office. He drove himself. He came alone. He brought written materials indicating advance preparation. He returned 6 weeks later with consistent instructions. None of that is consistent with impaired capacity. What is consistent with impaired capacity? Inconsistency. Confusion. Inability to recall prior decisions. Your father showed none of those things across 2 separate visits 6 weeks apart. The document examiner who will review the signature will find a tremored but deliberate signing pattern consistent with a Parkinson's patient in a period of functional clarity. What about the Harold Voss will? That, Catherine said, is where the conversation gets more interesting. Dr. Anand Mehta had been Gerald's neurologist for 6 years. He had kept detailed records of every appointment, including notations of cognitive status at each visit. This is standard neurological practice for Parkinson's patients. The progression is documented so that treatment can be calibrated to the stage. Catherine obtained Dr. Mehta's records through the legal discovery process. What they showed was a pattern that told the story of 2 wills more clearly than either document alone. For years ago, the period of the Harold Voss will, Dr. Mehta had noted at 3 consecutive appointments, patient presenting with increased confusion, difficulty tracking multi-step information, appears fatigued. Caregiver or family member present at all 3 visits, The caregiver or family member present at all 3 appointments, the records confirmed, was Sonia Walsh, Derek's wife. 2 years ago, the period of Catherine Bryce's will, Dr. Mehta had noted across 2 consecutive appointments, patient in notable clarity window. Oriented to time, place, and person. Recall consistent. Engaged and directive in discussion. No family member present. Patient arrived independently, No family member present. Patient arrived independently. The contrast was not subtle. The records documented, in clinical language, the difference between my father's cognitive state when he was accompanied by Sonia to Harold Voss's office and his cognitive state when he drove himself, alone, to Catherine Bryce's office. Catherine presented the records summary to me on a Thursday afternoon. The records do not explicitly say the Harold Voss will was signed under undue influence, she said. They say that during the period of the Harold Voss signing, your father was consistently assessed as confused and fatigued, with a family member present at all appointments. The court can draw its own conclusions. And the period of the second will. 2 documented clarity windows, no family present, independent arrival, consistent instructions across 6 weeks. She removed her reading glasses. Nora, I want to be straightforward with you about what this means. I cannot guarantee an outcome. I can tell you that the evidence supporting the validity of the second will and raising questions about the circumstances of the first is substantial, well documented, and will be presented clearly. What would you do, in my position? She put her glasses back on. I would let it go to the hearing. Your father did the work. He found me alone, he drove himself, he brought his list, he came back. He did everything a person can do in his circumstances to make his intentions clear and legally durable. A hearing is where that work becomes outcome. I would let it do its job. I thanked her. I drove home to the Greystone house. The house Derek and Pamela had been told was theirs. The house I had lived in for 8 years. The house my father had noted on his handwritten list with a percentage and a note in parentheses. I checked the medication whiteboard out of habit, even though there were no more medications to track. The hearing was on a Thursday morning in March. The judge was a woman in her 60s with the particular efficiency of someone who has presided over estate disputes long enough to understand that most of them are not complicated at their core. Harold Voss was present, representing the first will. Catherine represented the second. Derek and Pamela sat on one side of the room with their attorneys. I sat on the other side with Catherine. Harold Voss presented the first will. He confirmed it had been executed 4 years ago. He confirmed Gerald had been present. He confirmed the document met all formal requirements. The judge asked who had accompanied Gerald to Harold's office for the signing appointment. Harold reviewed his file. His paralegal had a note. A family member. Sonia Walsh, listed as emergency contact. The judge made a note. Catherine presented the second will. She walked through the execution, 2 visits, 6 weeks apart, Gerald arriving independently at both, no family member present, written materials prepared in advance, instructions consistent across both visits. She introduced Dr. Mehta's records as Exhibit A. The judge reviewed the records. She was quiet for a long moment. Dr. Mehta's notes for the period of the first will's execution describe the patient as, she read from the exhibit, presenting with increased confusion, difficulty tracking multi-step information, appears fatigued. And the period of the second will's execution is described as another pause, notable clarity window, oriented, engaged, directive. Yes, Your Honor, Catherine said. And the second will was executed approximately 2 years after the first. Correct. The testator drove himself to the drafting attorney's office for both visits related to the second will. Correct. It was the last time he drove himself to any appointment. The judge looked at the 2 documents on her desk for a moment. Derek's attorney offered the capacity argument, Parkinson's progression, the 2-year interval, the general trajectory of the disease. The judge listened. When the attorney finished, she asked one question. Counsel, are you aware of any documented instance of the testator expressing confusion or inconsistency during either of the 2 visits to Bryce Estate Law? No, Your Honor. Are you aware of any documented instance of the testator expressing confusion or inconsistency in the 6 weeks between the 2 visits? Another pause. No, Your Honor. Thank you. She made her ruling from the bench. The judge upheld the second will. Her ruling was 4 pages. The key paragraph read, the evidence supports a finding that the testator possessed testamentary capacity at the time of executing the second instrument. The documented clarity windows, the testator's independent action in seeking and retaining separate counsel without family involvement, and the consistency of his instructions across 2 separate visits constitute clear and convincing evidence of deliberate intent. The second instrument, being later in date and validly executed, supersedes the prior instrument. Catherine called me when the ruling was filed. It's done. The house. 70% is yours. The probate will take several months to complete formally, but the ruling is final absent appeal. Derek and Pamela have 30 days to appeal. Their attorney called me this morning and said they are not appealing. They were not appealing. The estate settled over the following 6 months. The Greystone house was appraised at $490,000, the market had moved slightly. 70% came to $343,000. The investment accounts, 60% of $320,000 was $192,000. Total to me, $535,000, plus the personal property from the house I had already been living in. Derek and Pamela each received approximately $97,000 and 15% of the investment accounts. There were no calls from Derek or Pamela after the ruling. I did not call them. I kept the whiteboard from the kitchen. The medication schedule was still on it, in my handwriting, in 4 colors for the 4 medication times. I kept it because it was the most accurate record of what 8 years had looked like, more accurate than any document, more honest than any will. I kept the back porch chair my father had been sitting in the evening he told me he saw what I was doing. I kept the photograph from his study, the 2 of us at my college graduation, him in a jacket he had pressed himself because he took occasions seriously, me in the cap and gown, both of us squinting in the May sun. I kept the note in parentheses. He had written it simply, without argument, without elaboration. It was not a legal phrase. It was an acknowledgement, the specific acknowledgement of a father who had run out of time to say it out loud and had found a way to write it down instead. He had been right that acknowledgement and payment are different things. He had given me both. Lessons from this story. The first lesson is about the architecture of a promise. 8 years ago, Nora Walsh was told that her contribution would be reflected in the estate. This is a common phrase used in families when caregiving is being negotiated, general enough to mean anything, specific enough to create an expectation. The promise was not kept in the first will. It was kept in the second. The difference between the two is not a matter of love or intention. It is a matter of who wrote the document and under what circumstances. The second will was written by Gerald Walsh alone, in a period of clarity, with a handwritten list, and it reflected exactly what he intended. The first will was written in circumstances the medical records describe as confused and fatigued, with a family member present. The same promise. Different documents. Only one of them reflected anything. The second lesson is about what a clarity window is worth. Gerald Walsh had Parkinson's. His cognitive capacity was not constant, it moved in windows, as his neurologist documented across 6 years of detailed records. He found his clarity window, used it to locate an attorney, and used the second window to sign. He did not wait for a perfect day because there were no perfect days. He used the best day available to him, twice, and he made each one count. A legal document created during a genuine clarity window, with independent counsel and no family present, is not a document that confusion can erase. It is a document that clarity built. The third lesson is this: a father who cannot stop what will be done in his absence can still determine what he leaves behind. Gerald Walsh drove himself to an attorney's office for the last time because he understood that the document in Harold Voss's files was not going to protect his daughter. He could not change what Derek and Pamela would do with the first will. He could not prevent them from reading it in an office on Church Street while Nora sat across the table and heard her name not mentioned once. What he could do, what he had time to do, in a window of clarity on a Tuesday morning, was write a correction. He brought his list. He knew what he wanted. He told Catherine Bryce, "The other will doesn't protect Nora. I need one that does." He was right. It did.